Good afternoon, everybody. My name is Regan Greer. I'm the Change and Communications Manager here at the QBCC. Welcome to our Invoices and Payment Practices webinar. Before we kick off, I would like to acknowledge the traditional custodians of the land on which we meet today and pay my respects to elders past, present and emerging. So before we go any further, I have linked a copy of these slides that you will see along with a handout that is mentioned throughout this webinar. It is available on our website and on the link to the page that I've put in the chat there, you scroll partway down the page and it's under the heading Recent Roadshow Handouts. Another thing is, if you would like to ask a question, on the right hand side of your screen you'll see a little questions area. Feel free to fire in your questions there. I will be going through and trying to answer as we go along. Historically in our previous webinars we've been inundated with questions. At the end of the presentation we will try and answer some of those out loud for you. If we don't get to your question, do not fear, we will collate the questions after the session and compile the answers and send them out to you. So today's session is going to be hosted by Laura Hatton, who is the manager of the Queensland Building Plan implementation team. I will now hand over to Laura, who is going to take you through the next 45 to 50 minutes worth of information. Thank you.
Good afternoon, everyone. So thanks for attending this afternoon session. As Regan mentioned, today I'll be talking to you around the changes for your invoices and the payment practice processes. And I'll also include detail of what the new requirements are around payment claims, payment schedules, and I'll give you some information on the other changes that are to defects and retentions as well. So let's talk about the new laws and why they have been introduced. Everyone deserves to be paid for their work. This hasn't always happened, particularly in the building and construction industry, but times are changing. So the second stage of the Building Industry Fairness Act, or BIF Act, commenced on the 17th of December last year, and it introduced changes to progress payments, adjudication and subcontractor charges. So the new laws are designed to ensure that security of payment and a fairer building and construction industry. They do apply to the majority of people who organise construction work or related goods and services for a construction contract for work in Queensland. Basically what this means is that if you are a payer in our industry, then you are impacted by these changes. So I will mention, I think Regan has as well, that you can plug in any questions that you have along the way on the questions tab on the side of your screen, and we'll have plenty of time to address the questions asked at the end. So what does this mean for you? The biggest change is to the way that payment claims are issued and paid. So a payment claim can now be a regular invoice and no longer requires an endorsement as a payment claim made under the legislation in order for the legislative protections to apply. So you will recall under the BICIPA, or the Building and Construction Industry Payments Act, so your invoices would used to have to include the words, "This is a payment claim made under the Building and Construction Industry Payments Act," for it to be considered a payment claim under the BICIPA. So it was the words, a sentence along the bottom of an invoice. So the changes to adjudication and this process, what they mean is that you no longer need to include those words. So basically, most of the invoices that you receive may be considered a valid payment claim made under the BIF Act. So the new laws are designed to encourage the communication between parties and ultimately help to ensure that people are paid for the work that they do or the goods and services that they have supplied. They're also designed so that every time that you issue an invoice, you should either be paid or you should receive a response. So this also means that every time you receive an invoice, so you're on the other end, and you've organised building or construction work to be completed, you must pay or provide a payment schedule to every invoice that you receive. So throughout the presentation, I'll use the terms invoice and payment claim interchangeably. I'll explain what exactly constitutes a payment claim later on. First question, who can be a respondent? So we do have two parties here that play part in the process. You've got the person who actually completes the work and is requesting payment, and that person is a claimant. And then you also have a respondent, so a person who receives an invoice that has engaged another person to perform construction work or supply related goods and services for the purposes of construction work in Queensland. So some examples of who can be a respondent under the legislation. So a respondent can be a developer. It can be a contractor who is ordering supplies or further contracting out work. Can be an owner-builder or a person who should hold an owner-builder's permit. Can be an investment property owner, a property manager who is organising maintenance work, or a business or commercial property owner. So the legislation or these new laws that I'll go through this afternoon do not apply to someone who is a resident owner. So that's someone who lives in the property as their principal place of residence. The most typical one here is your mum and dad. If you are directly engaged by a mum and dad or a resident owner of a property, and you give them an invoice for work that you have completed, the changes and the requirements that I go through this afternoon do not apply to the invoices that you give to a resident owner. They also don't apply to any invoices for work outside of Queensland. So you might do some work for a investment property in New South Wales. It's dependent on where the job site is actually located and where the construction work was carried out. If that is outside of Queensland, then the legislation and the requirements that I'll go through do not apply to those invoices. So as I've mentioned, these changes will impact the way that you respond to invoices. So as a respondent, someone who's organised construction work or the supply of related goods and services for construction work, I'll go through now what these new requirements are. So if you receive an invoice, you are required to either pay the amount in full by the due date for payment, or if you disagree with part of the amount claimed, then you need to respond within 15 business days or the time in your contract if shorter with a payment schedule. So this payment schedule needs to include your reasons for withholding payment. And if you are paying a lesser amount, you are actually still required to pay the lesser amount by the due date and respond with that payment schedule. So I'll go through in a bit of detail what these requirements are. Firstly, we'll look at what is a payment schedule. So a payment schedule is your response if you receive an invoice that you don't agree with. So a payment schedule needs to be a written document that identifies the payment claim you're responding to. So it could be invoice number received on this date. You need to state the amount, if any, that you're willing to pay. So it's a scheduled amount. It could be $0. It could be part of the claimed amount if you only agree with part of the claimed amount. And you also need to include all reasons for withholding payment or for paying a lesser amount. So it is important to include all reasons on that payment schedule, as these changes that started in December do mean that you can no longer provide any new reasons if it were to go to adjudication. So under the PSIPA, in certain circumstances, you were able to provide additional reasons that weren't originally raised in your payment schedule during the adjudication process. So this is no longer the case under the BIF Act if you're going through the adjudication process under the BIF Act. So next question is, how do I give a payment schedule? So your contract should actually specify how you are to give documents and notices to the other party. So it may include delivery to the person's place of business or other methods of service such as email. So you need to really be careful to make sure that you use the appropriate method of service as per your contract or as per the accepted practice between the parties. So as you would normally serve documents and notices and as what has been agreed upon by both parties. You need to make sure that the claimant actually receives the payment schedule within the correct timeframes. So that's within either 15 business days or earlier if specified in your contract. So if you are required to actually post a document or a payment schedule to another party, make sure you allow adequate time for postage and or delivery of that payment schedule. So it is also recommended that you keep a record of or evidence of service of these documents. So whether that be postage tracking numbers or copies of emails sent, as it will really be useful if there were a payment dispute and if you're going through something such as the adjudication process. So you're required to give a payment schedule if you are not going to pay the amount in full by the due date for payment. So some examples of when you might give one is if there is defective or incomplete work. If you receive an invoice and it wasn't actually given on or after a valid reference date, so you might have received 2 for that reference date, or you might receive it before the work's actually being completed. And if you didn't receive all of the goods and services that are included on an invoice, if the amount claimed is more than what was originally agreed upon in your contract, and then you don't have agreed variations, or if you are withholding retention money from the amount claimed on the invoice. So I'll go through that last one there. If you receive a payment claim and under your contract, you're able to withhold retention amounts. It's specified in that invoice. You need to make sure you pay the amount that's payable, but also respond with a payment for withholding this amount of retentions for these reasons. So because you have the ability to under the contract. So payment by the due date. It's important to note that if you agree with part of the amount claimed on the invoice, you must still pay this amount, the scheduled amount, to the claimant by the due date for payment. So providing a payment schedule does not mean that you can delay payment of undisputed amounts. The claimant should actually receive the money by the due date for payment. So it's not a transfer of money on that day. If you fail to provide a payment schedule, do you have to pay the full amount of the claim? So the answer is you may become liable to pay the amount claimed in full. So there are now consequences for failing to pay or provide a payment schedule. So if someone claims that you owe them money, the claimant, and you do not make payment or issue a payment schedule, the claimant may take action against you. So they may choose to pursue the debt via legal proceedings, subcontract charges, or adjudication. And they may also take action to suspend work on site. So failing to pay in full by the due date or give a payment schedule is an offence, and QBCC may take disciplinary action. So if they are a licensee, we do have the ability to investigate and potentially issue warning notices or consider suspension or cancellation of that person's license. So what happens if I provide a payment schedule late? You may become liable to pay the amount claimed in full. So same thing. I will mention as well that the changes, as I said at the start, are designed to really improve that communication between parties. So if you find that you've missed or forgotten about an invoice, first thing to do would be to contact the other party immediately, but you should also consider payment of that amount in full. So look at what the consequences are for failure to provide payment or a payment schedule within the timeframes and consider payment of that amount. So last question on the bottom of the screen there is what dates are the timeframes calculated from? So the timeframes, your 15 business days or earlier if specified in the contract to respond to any invoices received. It's actually calculated from the date that you receive an invoice. So it's not from the date that's written on the invoice. So I might receive an invoice today that's dated from 2 months ago. So my 15 business days or earlier if specified in a contract is counted from the day you receive an invoice. A business day excludes weekends, public holidays, and also the time between the 22nd of December through till the 10th of January. So it's a Christmas shutdown period. So we'll use an example. So say I received a payment claim on a Saturday or an invoice on a Saturday. The first business day or the date of business days or earlier to respond would be the Tuesday. So I've got 3 weeks from Tuesday to respond if I don't agree to an invoice that I receive. The next question is, do the changes apply to existing contracts? The answer is yes. The changes apply to any invoices given on or after the 17th of December. So that is to both new and existing contracts. And what about invoices from suppliers? Do I have to provide a payment schedule? If you're paying the amount in full by the due date for payment, then no, you don't need to provide a payment schedule. But if you disagree with the amount that's being claimed, then yes, you do need to provide a payment schedule, stating your reasons for disagreeing with that amount claimed. So last question here in regards to payment schedules is, if I don't have a written contract in place, what is the due date for payment? So if your contract doesn't actually specify your timeframes for payment, or you don't have a contract, then there are default timeframes in the legislation that apply to you. So the default due date for payment, or the time that you need to make payment for an invoice by, is 10 business days from the receipt of a payment claim. So I will mention here that a purchase order may be considered a contract if it contains contractual terms and if it is agreed upon by both parties. If your purchase order includes specific provisions around timeframes for payment, then just make sure that you follow these. A similar thing with your suppliers, if you've got trading terms such as 30-day accounts, as long as you agree with the invoices and pay in full by the due date, as I mentioned before, you do not need to respond with a payment schedule. So a couple of takeaways in regards to payment schedules. The first one there, in bold at the top of the screen, is remember that every payer in the building and construction industry is affected by these changes. So make sure that you action all invoices that you receive. Do you agree with the amount claimed? Then pay on time. Do you agree with part of the amount claimed? Then pay the part amount that you agree with by the due date for payment, and also respond with your payment schedule within 15 business days or earlier if specified in your contract, explaining all reasons why you disagree with the rest of the amount claimed. Do you disagree with the amount claimed altogether? Again, respond with your payment schedule within 15 business days or earlier, and make sure you explain all of your reasons for withholding payment. So now let's look at the other side of the story. So what to do when you're actually sending your invoices. So you are a claimant in this instance. So first question there is when to give an invoice. You need to make sure that you give your invoices on or after a valid reference date, that only one is given per reference date, and that it's within certain timeframes of when work was last completed. So a reference date, so everyone knows, is the date that you can request payment. So your contract will typically specify when this date is. It might be weekly payments, it may be on stage completion of work. Just make sure you go back and check your contract of when that request for payment can be. You should also have the ability to have a final payment claim submitted. If your contract doesn't actually specify a reference date, then the Act again provides a default reference date, which is the last day of the month. So I don't have a written contract in place, or my contract doesn't specify, and if I do work in January, I would need to wait until the end of January to issue a payment claim using the reference date of the last day of the month of January to claim payment for that work that I've completed. So the timeframes that I mentioned there, so the correct timeframes that are required for your normal progress payments or one-off payments, so that would be for a quote or a purchase order. then the invoice needs to be given within 6 months of when that work was last completed. For your final invoice, so this is where you might be claiming release of any retention amount held, your invoice needs to be given within 6 months of when work was last completed, or within 28 days of the end of the defects liability period. And I will mention here that you should now be prompted to send this final payment claim, as a hire contractor is now required to notify you of the end of the defects liability period. So I'll go through what the requirements are around that notice at the end. Let's look at what to include on your invoice. So I mentioned at the start that a payment claim no longer needs to include an endorsement that it is a payment claim made under the Act. So what a payment claim does need to include is you need to make sure it's a written document that identifies the work or the goods and services completed, that states an amount that's owed, and also requests payment of that amount. So let's look at a sample invoice. On the handout that there's a link to, there's also one available on the QBCC website. There's a copy of this template payment claim. So we'll go through it together now. Number one, we've identified the work or the goods and services completed. So we've got a job number and a description of the work that's been carried out. We're stating an amount that's owed, itemized amounts, and a total down the bottom. And we're also requesting payment of that amount. So down the bottom, these words are no longer mandatory, but they do assist, which is why we have them listed there. And it says, please pay the total amount on or before the due date for payment. It talks about what is the governing legislation, and it talks about how long that person has to respond if they disagree with that invoice that they receive. So it's just a bit of extra information to assist the other party when they receive this invoice or payment claim. And it is not mandatory. What you do need to make sure that you do is that you request payment of an amount that's owed. So a request for payment, and the legislation is clear that the words invoice are enough to constitute a request for payment. So if you're issuing tax compliant invoices, you'll most likely have the words tax invoice at the top of your invoice. You also have your ABN, the GST, amounts excluded, etc. So I'll show you another example of what may be considered a payment claim. I will put the caveat that this is a very basic example of what may constitute a payment claim. So it's an email. It says, just letting you know that I estimate the value of variation number 2 to be $5,000. I'll let you know the exact price once I've scoped the work. Let's go through it together. We're identifying the work, variation number 2. We're stating an amount that's owed, $5,000, but nowhere in it are we actually requesting payment. So I haven't used the words invoice. I've just said that I'll let you know the exact price once I've scoped the work. So as I mentioned, you need to make sure that your payment claims are issued in accordance with your contract or as agreed upon by both parties. So are you able to send a document or notice to the other party via email under your contract? Then yes, you may be able to send as an email. But make sure you go back and check your contract and make sure you're giving them as per the requirements of your contract, or as per the acceptance that, or the practice, sorry, that is accepted or agreed upon by both parties. You also need to make sure that you issue them on or after a valid reference date, that only one is given per reference date, and that they include that basic information. So work completed, an amount that's owed, and request payment. So let's look at what to do if your invoice is not paid. So I mentioned that the legislation has been introduced to really encourage that communication between parties. So the first step that I recommend that you take is that if you haven't received payment or a response to an invoice, is to contact the other party and follow up on the invoice that you've given. As I said, they may have missed or forgotten to make payment by the due date. You also have the option to include in your next invoice any money that is still outstanding from a previous invoice if it relates to the same construction contract. So I'll give you an example there. Same example that I've done work in January. I've got to the end of January and I've issued my January invoice or payment claim. I go back and I complete further work in February. If it comes to the end of February and I'm preparing my February invoice and I still actually haven't been paid for my January one, I can consider including any amounts that are still outstanding in that February invoice if it relates to the same construction contract. So if you're still having trouble receiving payment or a response to an invoice, so you haven't received a payment schedule either, or you're promised payment and don't actually receive it by the due date, then you can consider what your rights are. So some of your rights are to suspend work, or you could also start one of the dispute resolution processes. So that would be adjudication, subcontractor charges, or also progressing through the courts to actually secure payment of that amount that you're owed. So strict timeframes do apply for these processes, and it is recommended that you seek advice before commencing any of these. So you can contact the adjudication registry that sits within QBCC. And the adjudication registry has specific contact officers or customer services officers that can answer your questions in regards to what timeframes are required, what do you need to include in your application, how much it will cost, how long does it take, everything like that. The other option listed there that you have is to lodge a complaint with the QBCC. So we can investigate whether or not an offence has been committed, but what we can't do is enforce that the other party pays the amount that's owed. So that's where you really do need to look at one of those dispute resolution processes. So adjudication is something that's quite quick and cost effective. And basically the other changes that commenced in December mean that if you have an adjudication decision, you'll also be given what's called an adjudication certificate within 5 business days of receiving the adjudication decision. And that adjudication certificate you can lodge as a judgment debt in the courts. So if it is a QBCC licensee and you've made a complaint to us, we can investigate whether or not an offence has been committed. And like I said before, we may be able to take disciplinary action. So look at warning notices, suspension or cancellation of a person's licence. A monies owed complaint can also be lodged if there is an undisputed debt. So that's all I actually had to go through in regards to payment claims and payment schedules. So it leaves me with the information on the changes in regards to defects and retentions. So these changes also commenced on the 17th of December last year, and they were introduced to basically assist subcontractors in receiving the final retention payments. So the first one that listed there is that there is now a requirement for a contractor to provide a notice to their subcontractor to signal the end of the defects liability period. So this notice must be in the approved form and provided within either 10 business days from the end of the defects liability period or within 5 business days of receiving notice from a hire subcontract that it relates to. So I will note that this requirement does not apply to someone that enters a contract as a principal. But if you're a contractor and you're further subcontracting out work, and if you're withholding any retention amounts or securities, then you must give this notice to your subcontractors, itemizing or detailing the amount of retentions that have been withheld, and basically signaling that they can issue you with their final payment claim for release of that retention amount. So our website has some more information on what this requirement is, including the template or the form that's to be used to give notice. So the second one listed there is that there is now a default defects liability period of 12 months if retention or securities are being held under a contract, and there is no identifiable period for release of these funds or securities. So basically, if you have a contract in place that specifies that you can retain retentions or securities, and then it doesn't actually specify the date for release of this retention amount, then the automatic or default defects liability period will be 12 months from when practical completion occurs. So at the end of the 12 months, you'd issue the notice to your subcontractors to signal the end of the defects liability period, and they would issue you with their final payment claim, requesting release of those retention amounts being withheld. So final one there is that there is now a requirement to release any retention amount that is not the subject of a dispute to the contracted party in accordance with your building contract. And there is a significant penalty, including imprisonment, for a failure to do so. So this change does apply to both new and existing contracts, and it is very important to understand and follow. So basically, if there are any undisputed retention amounts being withheld, make sure that you release them when they are due and payable under your contract. So just in conclusion, why have these laws been introduced? So basically, as you will probably all know, that there is a history of poor payment practice in the industry, including delayed or non-payment. These laws have been introduced to improve that communication and cash flow for everyone. So change is required, and we do need your help. And what you can do is make sure that you are issuing valid payment claims. So make sure that they are given within the correct timeframes, so that's on or after a reference date, only one per reference date, and that they include that basic information. So it's a written document, identifies the work you've completed, states an amount that's owed, and also requests payment. Second one listed there is make sure that you action all payment claims that you receive. So as a respondent or someone that organises any sort of construction work or related goods and services for construction work, make sure that you action any invoices you receive. So either pay in full by the due date and or respond with a payment schedule within 15 business days, stating all reasons why you disagree with the payment claim or invoice that you've received. Last one that's listed there is action any payment claims that are outstanding. So that's your communicate with the other party, consider including any amounts that are outstanding in your next payment claim that you're issuing, or also look at what your options are to either suspend work or start one of those dispute resolution processes so that you can enforce payment of an amount that's owed to you. So that brings me to the end of the actual presentation. I will address some of the questions that have been asked. If anyone is willing to run away before you go, I will just point you to some really great resources that are listed on the screen there. So the second one is Protecting Your Payment Rights booklet. So that's a booklet that's available on our website that goes through all of the information that I've talked with you about this afternoon, as well as what those payment dispute options are. So it goes through subcontractor charges, adjudication, has a really good flow chart on the timeframes for adjudication. And I really suggest that everyone jumps online and has a look at that booklet. If you do have any questions that you're wanting to email through to us, you're more than welcome to send us an email at queenslandbuildingplan@qbcc.qld.gov.au. Or if you have a question relating specifically to adjudication, I'd suggest that you email registry@qbcc.qld.gov.au. So let's have a look at some of the questions that have been asked. Bear with me a minute. So first one that's listed here is, how does QBCC become aware that a payment has not been made or a payment schedule has not been issued? So the answer to that is that there are a number of avenues. So we don't see every single payment claim or invoice that's issued in our industry or what schedules are issued. So that's obviously something that occurs outside of QBCC's awareness, and it would take something such as a complaint or an adjudication application or decision, for us to be notified that payment either hasn't been made or a payment schedule has not been issued. So we would consider actioning any complaints that we receive. So we'd investigate and have a look at whether or not an offence has been committed and whether or not it is appropriate, and what enforcement action is appropriate to take. So whether or not it should just be education in the first instance to let them know that these are the new laws and the new requirements around it, or whether or not this is a party that is continually doing the wrong thing, that has a history of poor payment practices, and that whether we think that a more significant action is necessary. So the other way that we may become aware, I mentioned, is if there's an adjudication decision that's come back, we would look at referring that through to our compliance team. So another question is, can you please just go over what a reference date is? Is this the 15th of every month, or is it weekly, fortnightly, monthly? So I did cover off on what a reference date is, and that it's normally specified in your contract. So basically it's the date that you can claim for a progress payment, the date that you can claim payment for work that's been completed. So it would be your progress payment. It would specify, yes, it might be weekly, fortnightly, monthly, or it might be on stage completion of work. Or if the contract doesn't actually provide for a reference date or when you can make claim for payment, then it's the last day of the month in which the construction work was first carried out or the related goods and services were first supplied under the contract, and then every subsequent month after that. So say I did work in January, I don't have a contract or my contract doesn't specify, I need to wait until the last day of January before I issue my payment claim. So I can issue it on or after the last day of January. And then with it being every subsequent month after that, if I didn't actually use that reference date, so I forgot to issue my invoice, and then I've gone, it's now March, and I've realized I've never actually issued an invoice for the work I've completed in January, and I haven't used that reference date, then I can issue an invoice in March using that reference date of the last day in January, requesting payment for the work that I've completed in January. So next question that's listed here is, what if the invoice is incorrect? So it includes a different amount to the quote, for example. Can you request for them to reissue a correct invoice with the correct amounts, or do you still have to go through the payment schedule process? So this is where it really depends what your relationship is with the other party, and strongly suggest anyway that you respond with a payment schedule, and just stating that, look, the invoice you issued is incorrect. It's a different amount than what was on the original quote. Please send me a correct invoice for tax purposes. If you still agree with the amount that's actually claimed, or part of the amount, still consider paying that part amount by the due date for payment. But yeah, make sure that you respond within the timeframes or pay by the due date for payment. Next question that I have is, does this apply if an invoice is prior to December? So I went over that question in the actual presentation. So the changes only apply to invoices that are issued on or after the 17th of December 2018. So I might actually have an existing contract in place from, let's say, July last year. I've been doing work with that party. Any invoices that I issue prior to the 17th of December, the legislation that applies to those invoices is the Building and Construction Industry Payments Act, or the BSIPA. So if I'm struggling to receive payment for an invoice that's issued prior to December, then I'd need to look at what my options are under the BSIPA to lodge an adjudication application. So there are different slightly different timeframes and slightly different requirements. So you may need to issue what's called a second chance notice before you apply for adjudication. And because they are different requirements, I'd strongly suggest that you give our adjudication registry a call on 139333 and select option 3, which will take you straight to those adjudication registry staff, and they can give you specific advice around that adjudication process under the BSAPA. So I've got another question here is, does the Act cover professional consulting services, so such as consulting engineers? So the answer is yes. If the work being undertaken is in relation to construction work, so the BIF Act uses two specific definitions of what this legislation applies to. So that is both the definition of construction work and a definition of related goods and services. So you can, if anyone really wants, can jump into the legislation and have a look at what those two definitions mean. But basically, it does include engineering services. It includes everything from if it's landscaping, painting, light fittings, tiling, other services, so architects services, maybe some sort of designers. That's all included in the definitions of construction work and related goods and services. So it does need to be relating to a building site that's in Queensland, and then it doesn't actually apply to an invoice that's given to a resident homeowner. You need to remember that one as well. Let's just try and find a couple of other questions out of the list. So on an invoice, can you put the dates that you require payment, or is there a set time frame? So on your invoice, I definitely recommend that you state what your due date for payment is, but it needs to be as per what is in your contract. So you can't request different timeframes from what's actually agreed upon in your contract. So if your contract doesn't specify, though, there is a default timeframe that applies in the legislation. So that default timeframe is 10 business days from the date the payment claim is received. So if you're happy to go with that date and you don't normally work with contracts, so you might work for building work that's under the amount of 3,300 or other sort of work that's not considered building work under the QBCC Act, then you can consider what the default due date for payment is, which is 10 business days under the BIF Act. So another question here is, do you have to provide a payment schedule in response to fraudulent invoices? If you don't, do you automatically become liable to pay? So biggest take home today is that make sure you action any invoices that you receive. If you do believe it's been incorrectly been given to you, whether or not you're the actual contracting party, whether or not you think that they have a valid reference date to issue you, or whether you believe that they're claiming for much more than what was originally agreed upon, then make sure that you respond with a payment schedule. So if you don't intend to pay in full, make sure you respond with a payment schedule within 15 business days or earlier if specified in your contract. So that other party, if you don't respond, can consider taking that to adjudication, and potentially you may become liable to pay that amount in full because you've never actually paid or responded to that invoice that you've received. So I might just pick one or two more and then leave it at that. So if I've given a final payment claim at the end of my completed works, but I have not received any retentions, so they are due 12 months from practical completion, can I still claim? So just let me try and get my head around what that question is. If I've given a final payment claim at the end of my completed works, but I haven't received any retentions, are they due 12 months from practical completion? So I will refer you to the QBCC Act. There are requirements around how much retention can be withheld past practical completion, and that's relating to certain contracts. So for a lot of contracts, you can't hold more than, I believe it's 2.5% past practical completion. So you would typically receive some sort of payment on that practical completion date, and then you would receive the rest of the amount, which is your retention amount that's being withheld, at the end of the defects liability period. So with the new requirement, you should now receive a notice to signal that end of defects liability period. It will be in a form from your contractor, and that will prompt you to issue your final payment claim requesting the release of any retention amount being withheld. So if you have issued that final payment claim and you're still struggling to receive payment for that final retention amount, don't just leave it. I'd look at what your options are to go through one of those adjudication processes to ensure that you actually paid that final retention amount. You should also look at lodging a complaint with QBCC. As we mentioned, there is now a significant offence for failing to pay any retention amounts that are undisputed. So I might leave this as my final question. Feel free to keep putting them in though, because we will have a look at addressing all questions lodged and sending out a full list of questions and answers in the coming days following today's session. So final question, if you are part paying a claim, do you still need to respond with a payment schedule within 15 business days, or can this be issued at the same time as the part payment? So this is where your timeframes may not quite align. So it depends what your due date for payment is or when you need to make payment by. So you might actually have a due date for payment of 30 business days. So if that's the case, or sorry, 30 days. If that's the case, then make sure that you do respond with a payment schedule stating why you only agree with part of the amount and that you're only going to pay part amount within 15 business days or earlier if specified in your contract. So it might be different. Under the Act, I've talked about the 10 business days due date, default due date for payment. So it may be different. So you may need to make payment by 10 business days, and then you'd have an additional 5 days to respond with a payment schedule, but it could be the other way around. So just check your contract and what your requirements are in regards to timeframes. So I might hand back over to Regan to go through a couple of things. But thank you everyone for attending and lodging your questions.
Thanks, Laura. I just wanted to address, I've been sitting here trying to answer a whole lot of questions that have come through, and this sort of follows on from one of the questions that Laura had answered in the middle there about fraudulent payment claims. So I just wanted to clarify this. So the extra question that's come through off the back of that was, your explanation for fraudulent payment claims does not take into account the amount of scam invoices that are sent. Normal practice is to simply delete such scam emails. So it is now sounding that if we don't respond, we'll be liable to pay. How could this be possible? Okay, so what Laura was trying to outline is that if you, yes, ideally, you should respond with a payment schedule outlining that, no, you're not going to pay because this is fraudulent. But on the flip side of that, in reality, you may be getting, I don't know, in our roadshows, we've heard recently that some people are getting up to hundreds a week. So if we look at it in practical terms, for someone to make you liable to pay, if for example, I had sent you a fraudulent payment claim, and you didn't respond with a payment schedule, it would be up to me as the person claiming that you owe me money to look at pursuing that through adjudication. Now, to fill out an adjudication application, if you've never been through that, or to try and pursue you through court, I have to provide evidence that you've actually done that work. So if I filled out an adjudication application fraudulently, that adjudicator is going to need actual evidence to base their decision upon. So it's when we say liable to pay, it also needs evidence that you've done that work. So it would actually take quite a bit further for that person who's claiming fraudulently that you owe them money. There's quite a few steps involved for them to go through and lodge that adjudication application and that information. So I hope that that clears that up for you. There's a whole host of other questions here. As Laura mentioned, that we will collate all of these and put the answers to them and send them out or to you. There's a lot of fantastic questions, and these questions are reflective of questions we've been asked at previous webinars and roadshows as well. So it's fantastic to see. Thank you for attending our webinar. As I mentioned at the beginning, these slides and the handouts that Laura has mentioned are available in the link in the chat on the right-hand side. It is on our website. For those of you who are going to look at attending our next webinar that starts in a few moments on minimum financial requirements, you may also like to go to that page and have a bit of a preview of these slides that are in that presentation. Thank you all very much, and I hope that you have a wonderful weekend.